Time to do a case study on an adult dependent relative application we did recently. We did the application was refused at first, and then we had to go into an appeal, and now we've got the appeal decision and the appeal has been allowed. The reason I chose this is because a lot of people are in similar situations. A lot of people will be able to relate to the idea that they have parents or aging or elderly parents or a surviving parent who is finding it difficult to live by themselves in their country, and they wish to come and join the rest of the family in the UK. And of course, when people think whether or not I can bring my father or my mother or both my parents over, surprisingly, the immigration rules do not allow you to do that. The immigration rules only allow for an adult dependent relative application to be made, which can be done for a parent, it can be done for an uncle or auntie, it can be done for a sibling, whoever is in that kind of situation that falls within the definition. Now, what is the definition? You have to make sure that you are related, first of all, to the sponsor. The sponsor is either a British national or a person present and settled in the UK or somebody with refugee status. So what happens there is we are talking about those applications where there is a surviving parent or both parents and they wish to join the sponsor in the UK. So what are we saying? We are saying that because of their age, illness or disability, they're unable to look after themselves on a day-to-day basis. And they wish to come to the UK so that they are able to live with their family. Now, when we do these applications, we need to produce a lot of evidence. We need to confirm a lot of points. We need to make sure that all the things that are covered under the immigration rules are covered in that application. So what are those things? First of all, like I said, age, illness or disability is causing the problems. Because of that, they are unable to look after themselves on a day-to-day basis. What is that? They can't cook, they can't clean, they can't take care of their personal hygiene, they can't take care of medication, they can't take care of any groceries that they need to do, things like that that come on an everyday basis. That is what we're talking about. Now, what also we need to prove is that those difficulties cannot be overcome. So the care that they require is either not affordable or not available in the country that they're living. Now, all these things I've discussed in previous videos quite extensively, so I'm not going to go into a lot of detail about the rules. What we want to do is just doing this case study. Now, I've got the details here. This was an Indian lady, 68 years of age, living with a lot of medical issues. Now, of course, the medical issues we talk about are subcontinent problems, the diabetes, the hypertension, the cholesterol levels, the kidney problems. These are things which are very common to that part of the world. So she had the lot. She had all the problems. And so far, she had been living with either servants or somebody. Now, she had a son who was living in India, but decided to move over with his family because he found a good job and he found a good opportunity to extend his career and to go ahead with his life. So he had to move out. Now, the position of the Home Office in this application was that, first of all, she can be taken care of because these are long-standing problems. She has had difficulties before, but she's been managing them. So there is no reason why she cannot manage. Secondly, they said she is getting all the treatment that she requires because you have provided medical evidence of all the problems, and the fact that there are doctors and hospitals looking after her show that there is obviously care available there. Thirdly, they say that there is a daughter living in India who's, by the way, married, lives 2 hours away, has her own in-laws to look after, has her own kids to look after. But the Home Office position was that since there is a relative living in that country, they can look after you. Now, if you have done any of these applications or you have heard of other people doing these applications, these are the common refusal points that you will get. Another point that they've started adding in recent cases is that we don't believe that the sponsor's financial documentation has been provided properly. This is despite you providing bank statements and the sponsor's employment letters and pay slips to confirm how much income they have. But still, the Home Office creates these issues now. So what happens in this matter, we got everything together. We put in the application, we submitted the application, which was refused by the Home Office within 2 to 3 months. And once the refusal was done, after that, we lodged an appeal. We took the appeal, we prepared all the documentation the way we like to prepare appeals. And this is a very specific appeal point that I want to mention here. when I take on an appeal matter, and I don't know how other people are doing it or how other firms are doing it, I know how I have seen people doing it in the past, and I don't agree with that. I don't agree with going right till the end when your appeal is to be heard in a couple of weeks' time or 3-4 weeks' time, and then start preparing documents and all of that. No, that is complete rubbish. What you need to do is, as long as you understand what needs to be done, as soon as you submit the application, the appeal, as soon as the appeal has been lodged, we carry out our own CMR. The CMR is the case management review of the matter. We will go through the evidence. We will go through all the documentation required from you and what should be in your witness statements and things like that. That's how we start a preparation of the appeals. We don't sit around waiting for the Home Office to do something or for the appeal hearing to come up. So we prepare the documentation. We put everything together in an appeal bundle, the skeleton arguments, your chronologies, your supporting evidence, all the research that needs to be done, any medical evidence that needs to go into there, any evidence of any care facilities available or not available, any care arrangements, all those things, we take care of that right in the beginning for the appeal preparation. That is how an appeal bundle needs to be prepared. So months in advance of the hearing, your appeal is ready to go. That bundle then goes to the Home Office and they will carry out a review. In their reviews, they will normally just say, well, we don't accept this. We are going to just continue with the refusal letter and we request an oral hearing. That's when you go to court. Now, with our cases at Bukhari Chambers, I try to go for every single case. Of course, it's not possible for me to go for every single case. So if there is a clash in court hearings or anything like that, then we have a very small list of barristers that we go through and that we work with. And those barristers know Bukhari Chambers very well and they understand what the demands of our clients are. So this matter, we went into appeal. I represented the clients in court. The appeal was heard in Birmingham. It was probably a lengthy-ish kind of hearing. It went for about 3.5 hours. The Home Office completely coming out of the blocks, firing at all cylinders, saying she's got care available over there. She's got doctors' treatments available there. She's got hospitals available there. She's got a daughter there. You can send money, this and that, all sorts of things that they say. We had answers to everything. And that is what experience teaches you. So over the years, since we have been doing these applications for over 10 years now, these ADR applications have become somewhat a kind of a specialism for Bukhari Chambers. And I'm very, very proud of that. And for the simple reason that I went through these problems with my parents myself. So I understand firsthand how it is to be on the phone when your father is actually suffering or having a heart attack. In my case, this is what had happened. So this is the kind of situation where I understand fully what people go through. And this is how we are able to approach these cases on a personal level on a daily basis. And that is what helps, because when I go to court, I always say to my clients that 80% or 90% of your work is done in the preparation of that appeal. If you have a rubbish appeal prepared and you send the best barrister to court, he's not going to be doing anything, or he's not going to be able to do anything unless all your initial preparation has been done properly in the appeal bundles. And that is what we had. So we had a full-blown court hearing, and at the end, the judge agreed with every single submission that I had made. And that is the fantastic thing about it. So very proud of it, very proud of the team at Bukhari Chambers who put the bundle together. Of course, like I always say, I supervise my team, but I've got people who work with me, who have been trained by myself, and who take this matter on a day-to-day basis and prepare things according to my instructions. And then, of course, I supervise them. So I just wanted to share all these things. I've talked about the adult dependent relative applications, their requirements today. I've talked about how an appeal needs to be prepared and what we can do and what our process and what our systems are. So I hope if anybody needs help, you know where to go. And inshallah, speak to you soon. Thank you very much.